Welcome to the McNees Labor and Employment podcast series. This podcast will address the overlap between the FMLA and the ADA by Kelley Kaufman, attorney at law. Ms. Kaufman practices in the Labor and Employment Group at McNees.
Thank you for joining me for this podcast, which will briefly discuss the intersection of the FMLA and the ADA with respect to employee personal medical leaves of absence. While there are other state and federal laws that can be implicated by employee medical leaves of absence, this is one issue that regularly comes up for employers. The Family and Medical Leave Act applies to employers with 50 or more employees. Under the FMLA, an employer must provide eligible employees with up to 12 weeks of unpaid, job-protected leave in a 12-month period for the employee's own serious health condition. The Americans with Disabilities Act applies to employers with at least 15 employees and prohibits discrimination based on disability. In addition, the ADA requires employers to provide disabled employees with a reasonable accommodation to allow them to perform the key functions of their job. To evaluate whether a reasonable accommodation exists, the employer must engage the employee in an interactive process. In many cases, an employee's qualifying serious health condition under the FMLA also will meet the definition of disability under the ADA. As a result, requests for medical leave under FMLA can also implicate the ADA and vice versa. For this reason, employers must recognize that the exhaustion of an employee's FMLA leave entitlement may not be the end of their obligations under the ADA. At the end of a leave period, the employer must engage the employee in the interactive process to assess their ability to return to work with or without additional accommodation. For employees who are unable to return to work following the expiration of their FMLA leave, an additional leave of absence may be required as a reasonable accommodation under the ADA. For a number of years, the Equal Employment Opportunity Commission has been aggressively challenging so-called inflexible leave of absence policies under the ADA. These are policies that provide for the automatic termination of employees who cannot return to work after exhausting a fixed period of leave, whether that's the 12-week FMLA leave entitlement or some additional period of leave provided under company policy. Notwithstanding the EEOC's position, multiple federal courts have made clear that the ADA does not require employers to provide an indefinite leave of absence or an accommodation that may cause an undue hardship to the employer. It is important, however, that each of these scenarios, as with any accommodation scenario, is evaluated on a case-by-case basis. Medical leaves of absence and accommodation issues can be very difficult for employers to navigate. The legal obligations are complex, and no set of circumstances is ever the same. Your company's best line of defense is to periodically audit its policies and procedures to ensure compliance with its legal obligations under applicable law. Employers should also designate a centralized department or position, such as human resources, to administer leave and accommodation issues. Finally, employers should ensure that their supervisors and managers and their leave and accommodation administrators are well trained to recognize and handle these issues promptly and appropriately. If you have any questions about the interaction of the FMLA, ADA, and other state or federal laws relating to medical leave and accommodation obligations, please contact us using the information on the screen.